Before we begin, I would like to share this verse, Proverbs chapter 13 and verse 15. Good understanding giveth favor, but the way of transgressors is hard. Every prudent man dealeth with knowledge, but a fool layeth open his folly. A wicked messenger falleth into mischief, but a faithful ambassador is health. Poverty and shame shall be to him that refuseth instruction. Welcome to the Law, Life, and Love podcast. This is Attorney Mo, and this is a podcast where we talk about the legal system. We help you navigate the legal system and understand some legal concepts. And this is also a podcast about exchanging life experiences and then talking about the things that we love. Anyway, I intended the first episode, the pilot episode, to actually be a background about the podcast, but there are pressing issues, na maraming nagtatanong sa akin, and I thought this would be a great opportunity for us to be able to talk about this. So, itong nais kong pag-usapan natin is about the recent arrest of a person who was involved in a car crash. And apparently, according to the general public and those who have seen the video, it's very apparent that the driver who was arrested was not in fault, but nevertheless, he was charged of reckless imprudence resulting to homicide. So, actually, hindi ko na-share yung video, because medyo sensitive and of course for the peace na rin of the parties. But the March 14 article from Philstar Global, it states that the driver of a Toyota Innova multipurpose vehicle which collided with a motorcycle rider who counterflowed on Skyway Stage 3 in Quezon City was released from police custody on Tuesday. The motorist, a 54-year-old man from San Mateo, Rizal, was freed after the criminal cases filed against him were dismissed, according to the police. The driver was ordered released by the Quezon City Prosecutor's Office, which dismissed the cases of reckless imprudence resulting in homicide and damage to property after the family of the motorcycle rider filed an affidavit of desistance. So, actually maraming nagiging comment na relating to this incident, talking about what reckless imprudence is. Pero siguro I'd like to take a step back and talk about arrest, because obviously this was a case of a warrantless arrest. Pag sinabi natin warrantless arrest, ibig sabihin the person involved in this incident was arrested without a warrant. So a warrant is actually issued by a judge, after determining probable cause. In this case, it was a warrantless arrest. So what are the instances where when a person may be arrested without a warrant? Actually, under the rules, Rule 113, ang nakalagay dito sa Section 5, arrest without warrant when lawful. So these are the three instances stated under the rules, but there are actually 5 which we will discuss later. Ito yung mga instances when a person may be arrested without a warrant. 1. When in his presence, the person to be arrested is actually committing or is attempting to commit an offense. 2. When an offense has just been committed and he has probable cause to believe, based on personal knowledge of facts or circumstances, that the person to be arrested has committed it. And 3rd, when the person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment or is temporarily confined while his case is pending, or has escaped while being transferred from one confinement to another. Actually, yung dalawa pang instances, the other can also be found in the same rule, Rule 113, Section 13. Sinasabi dito, arrest after escape or rescue. If a person lawfully arrested escapes or is rescued, any person may immediately pursue or retake him without a warrant at any time and in any place within the Philippines. The other instance, the 5th instance, is under Rule 114. This one under Section 23, where it states, ang sabi dito, arrest of accused out on bail. For the purpose of surrendering the accused, the bondsman may arrest him or, upon written authority endorsed on a certified copy of the undertaking, cause him to be arrested by a police officer or any other person of suitable age and discretion. An accused released on bail may be rearrested without the necessity of a warrant if he attempts to depart from the Philippines without permission of the court where the case is pending. So these are the instances when a valid warrantless arrest may be committed. Now, let me go back dun sa original na tatlo because dito papasok um, yung naging pag-aresto dun sa individual involved in the accident. Now, dito, yung first is when in his presence, the person to be arrested has committed, is actually committing, or is attempting to commit an offense. This is called in flagrante delicto or caught in the act arrest. So, dito, makikita natin that the arrest should be due to the fact that the person arrested has committed, is actually committing, or is attempting to commit an offense in the presence of the person making the arrest. So, yun. So, I guess in this particular incident, malabo na in their presence, no? Kasi makikita natin dun sa video, wala namang ibang mga motorists na nandun, walang law enforcement agents na nandun. So, probably papasok ito dun sa ikalawang klase na tinatawag nating hot pursuit. Ito yung letter B. Nakalagay dito, when an offense has just been committed and he has probable cause to believe, based on personal knowledge of facts or circumstances, that the person to be arrested has committed it. Now, in a number of Supreme Court decisions, nilinaw na ito. Kailan ba pwedeng gawin ng isang law enforcement officer or private individual gawin itong tinatawag nating warrantless arrest? In the Supreme Court decision, itong Supreme Court decision of Rogelio Gonzaga versus People of the Philippines, GR number 195671, decided in 21 January 2015, ang sinasabi dito, ang reckless imprudence, dinidefine dito kaning reckless imprudence. Ang sabi dito, reckless imprudence as defined in Article 365 consists in voluntarily but without malice doing or failing to do an act from which material damage results by reason of inexcusable lack of precaution on the part of the person performing or failing to perform such act. So dito, sinasabi rin dito, in order to establish a motorist's liability for negligent operation of a vehicle, it must be shown that there was a direct causal connection between such negligence and the injuries or damages complained of. To constitute the offense of reckless driving, the act must be something more than a mere negligence in the operation of a motor vehicle. A willful and wanton disregard of the consequences is required. Willful, wanton, or reckless disregard for the safety of others within the meaning of reckless driving statutes has been held to involve conscious choice of a course of action which injures another, either with knowledge of serious danger to others involved, or with knowledge of facts which would disclose the danger to any reasonable person. Verily, it is inexcusable lack of precaution or conscious indifference to the consequences of the conduct which supplies the criminal intent and brings an act of mere negligence and imprudence under the operation of the penal code. So, bakit ko ito dinidiscuss in relation to arrest? Now, the person arrested was arrested without a warrant. So, which means it was in flagrante delicto, pero as discussed and as I have shown you earlier, hindi pwede kasi hindi naman in his presence eh. So I would argue that hindi pwedeng in flagrante delicto yung arrest. Kasi while we may argue that the person has committed an offense because nagkaroon ng banggaan, nag-result ito sa homicide, and there is probable cause to believe that a crime has been committed, it was not done in his presence. Ngayon, so papasok ito dun sa ikalawang klase, yung tinatawag nating hot pursuit. Now, when an offense has just been committed and the person arresting has probable cause to believe based on personal knowledge of facts or circumstances that the person to be arrested has committed it. Now, dito gusto kong i-discuss. Ang sabi ng Supreme Court dito, in the case of People of the Philippines versus Leng Haiyun, GR number 242889, decided 14 March 2022. Ang sinasabi dito ng Korte Suprema, for this particular type of warrantless arrest, ang sinasabi dito, it is also known as hot pursuit arrest. Diba? So, ito yung mga requisites for the arrest to be valid. First, that the offender has just committed an offense. Two, the arresting peace officer or private person has personal knowledge of facts indicating that the person to be arrested has committed it. Now, in this particular case, the Supreme Court cited the case of Abilita III versus Police Superintendent Doria. Dito, sinasabi dito, this court found that there was a valid warrantless arrest under the foregoing provision. Police Superintendent Doria received a report about an alleged shooting incident. He thereafter instructed SPO3 Ramirez to investigate. SPO3 Ramirez reported that the accused therein, who was also implicated, just left the place of the incident. According to the Supreme Court, personal knowledge of facts must be based on probable cause, which means an actual belief or reasonable grounds of suspicion. The grounds of suspicion are reasonable when, in the absence of actual belief of the arresting officers, the suspicion that the person to be arrested is probably guilty of committing the offense is based on actual facts, i.e., supported by circumstances sufficiently strong in themselves to create the probable cause of guilt of the person to be arrested. A reasonable suspicion therefore must be founded on probable cause, coupled with good faith on the part of the peace officers making the arrest. Now, ang gusto kong i-point out dito, in this particular incident, we may argue that what the law enforcement officers did, or the arresting officers did, cannot be coupled with good faith, no? Kasi pag sinabi nating meron silang personal knowledge of facts or circumstances, ibig sabihin base ito sa kanilang pag-iimbestiga. At kung ito ay base sa kanilang pag-iimbestiga, it should have been brought to their attention, and I believe it was brought to their attention, that yung may actual recording, no, nung dashcam which shows yung negligent act of the driver. Now, I'm not gonna discuss yung tinatawag nating contributory negligence or torts. I'm just gonna focus dun sa arrest, no? Why am I focusing on the arrest? Kasi medyo unfair, no? Kasi isipin mo, whether or not the arrest is valid, kung ano man ang pag-uusapan natin, yung damage nangyari na. Nakulong na yung individual. If he is a working individual, he would have to take a leave. Of course, yung possible implications to his character, his reputation, nandun na yun, no? And of course, the stress of being detained, no? And the stress in the family. Kasi yung mga nababasa ko ng mga komento, no? Kawawa naman yung individual. Siya na yung nasa tama, nabangga na, damage na yung sasakyan niya, walang magbabayad ng damage ng sasakyan niya, siya pa yung nakulong. Now, looking at this particular decisions of the Supreme Court and the applicable provisions of law, may kita natin na in order to do a warrantless arrest, kailangan pa rin ng ating mga law enforcement agents na mag-conduct ng kanilang sariling investigasyon. At kung yun ay nagawa, no, what should have been done is hindi dapat na-book, or hindi dapat, kasi before you are arrested, ang tawag doon is booking, no? So in order for you to be arrested and detained, you would have to be booked. Ibig sabihin, kukunin yung fingerprints mo, kukuhanan ka ng mugshot, tapos tsaka ka i-detain. So pwede sanang ang nangyari, before detaining that particular individual, ang nangyari sana, inimbestigahan thoroughly. Kung nakita doon sa CCTV, for example, ng Skyway, kung available man yun, or doon sa dashcam footage, na talagang wala namang naging kasalanan yung individual, hindi sana pinakawalan na siya. Maintindihan ko sana kung ang sitwasyon ay walang available na pieces of evidence. For example, walang dashcam footage, walang witnesses, no, at may namatay na individual, then you would have to hold that particular person to answer. Tingnan kung merong probable cause. I-hold siya for inquest. So, ang ano kasi, totoo naman, there is presumption of regularity sa acts ng mga government officials, even our law enforcement agents, which means na yung kanilang act of detaining the individual within the prescribed hours, no, according to the revised penal code, meron silang either 12, 18, or 36 hours in case. Pero para sa akin, mas prudent siguro na ang ginawa kung napanood naman yung video at nakita naman talaga na walang naging kasalanan. No, kasi it may be argued na, bakit hindi niya iniwasan or bakit hindi siya pumreno. Pero looking at the picture, actually, may kita natin na medyo nakagilid yung sasakyan, which means he tried to veer away or steer away from the motorcycle. Pero, you know, to attribute yung dapat na ginawa ng driver at, kumbaga, sa isang split-second decision would be, kumbaga, asking too much from that individual. Placing ourselves in the shoes ng driver, no, na nagda-drive ka naman peacefully, Kung hindi ka naman overspeeding, you're following the rules, I don't think na merong matatawag na reckless imprudence. So sana, nung ganun yung nangyari, nung napanood yung video, kasi I'm not sure, no? This would be hypothetical kasi hindi naman natin alam kung na-present agad yung dashcam footage or na-review ba yung CCTV footage. Pero sana in the future, kung ganun man, no, na may mga dashcam footages, merong CCTV footages, wag na sanang i-book yung individual. Pwede naman natin kunin yung information ng driver, kunin natin yung registration ng sasakyan, ma-ascertain natin yung address, kunin natin yung driver's license, kunin natin yung address, yung pagkakakilanlan. And by doing so, pwede naman natin sila i-hold accountable later if we file a case sa Office of the City Prosecutor. But in the meantime, to determine probable cause based on our investigation, because probable cause is actually to ascertain whether a crime has been committed and is the accused probably guilty thereof. So, ibig sabihin, in determining probable cause, pwede na natin tingnan dito sa CCTV footage na to, kita natin, for example, sino ba yung nasa mali. Kung wala naman sa mali yung driver, then wag na sana natin siyang i-hold accountable by by placing him on arrest. No, we can hold him accountable by filing charges against that person to let him answer the charges. Pero yung kumbaga putting him at a disadvantage by placing him on arrest, 'di ba? Regardless if it's just a number of hours or overnight, kasi medyo stressful yun, no? So, I understand there is also a process to question yung warrantless arrest, di ba? You may file for a petition for habeas corpus, di ba, to question yung arrest. But then, even that would be working against the individual who is already arrested. So, para sa akin, parang ang mas magandang ginawa sana, 'di ba? Base sa investigasyon, exercising prudence, placing yourself in the shoes of that particular individual, what would you do, 'di ba? Would you hold him accountable by filing charges, arresting him, detaining him while waiting to be processed for inquest, or i-discharge mo na lang muna yung person tapos charge them kung gusto mag-press ng charges ng kabilang or kung ma-determine ng police that there is reason to hold the person liable, then, di ba, pwede pa rin naman i-file yung complaint affidavit and then i-subpoena yung individual to answer for the charges. I suppose there are other ways, no, to address this. I've read somewhere that there was a pending legislation na to make these individuals not liable, no, kung may mga particular instances, no, na nababanggit. There's a pending bill filed in Congress, no, House Bill number 10123, or the proposed Philippine Responsible Driving and Accountability Act. At sinasabi dito, historically, there have been cases where drivers were blamed, worse, even put behind bars, despite evidence showing the ones at fault were the other motorists or pedestrians. So dito sinasabi ng batas, no, yung instances kung saan hindi dapat i-hold liable ang isang individual because of, reckless driving. Lalo na kung mapatunayan na ang may kasalanan naman ay yung kabilang partido. So I guess that would be a good move, no? But in the meantime, I think what is more pressing is that siguro our law enforcement officers, law enforcement agencies would exercise more prudence to determine probable cause, diba? Kasi yun naman yun to be able to effect a warrantless arrest, there should be probable cause coupled with good faith. So in this particular incident, yung personal knowledge should be based on the investigation. And in the course of the investigation, if the police officers, the law enforcement agencies can determine that the person who is involved in the accident is not at fault, then wag na sanang i-book for detention para ma-inquest pa and then wait for the resolution of the prosecutor to let go of that particular individual. Kasi sayang yung oras, no? Sayang yung oras na nagugugol nung particular na individual, whether that is a few hours or overnight or even just a few days, no? Hindi nagmamatter yun kasi yun ay nakakaapekto sa mental health, hindi lamang ng individual who is arrested but of course the family. So, yun lamang po. Maraming salamat. So if you love more content like this, no, continue to follow the Law, Life and Love podcast at maraming salamat po at magandang araw po sa inyo.